My Lords, we refer to Order 36, Rule 4.3 of CI 47 and CI 87, 3E sub 5. My Lords, Order 36, Rule 4.3 of CI 47 and my Lords, Order 38, Rule 3E sub 5, that is as amended by CI 87. As amended by CI 87, my Lords. My Lords, we also rely on Section 62 of the Evidence Act, NRCD 323. But with your kind permission, if I may read Section 62 sub 2. If a witness who has testified is not available to be examined by all the parties to the action who choose to attend and examine, and the unavailability of the witness has not been caused by any party who seeks to cross-examine the witness, the court may, in its discretion, exclude the entire testimony or any part of the testimony as fairness requires. My Lords, the Evidence Act. Yes, my Lord. My Lord, the point I chose to make with this section is that even if a witness enters a witness box, yes, very well.
Was teaching that at the end of the evidence of the petition, the defendant or respondent can lawfully elect not to proffer any evidence in the case. That is the issue before us.
And my Lords, I made that point yesterday, and it is the case for the first respondent that having the evidence of the witnesses of the petitioner and the cross-examination by us, it is a humble submission that we do not require any further evidence for this court to determine this matter, and therefore we do not intend to call evidence. Lord, I wish to refer your lordships to the case Hydrofoam Kahama versus Hydrofoam Estate Ghana Limited, the Ghana Law Report. Yes, my Lords, 2013-2014, 2 Supreme Court of Ghana Law Reports, 1551. My Lords, at page 1567. Lords, with your kind permission, if I may read what the
title of the case is.
Arma, my Lord, Arma versus Hydrofoam Estates Ghana Limited. Hydrofoam. My Lord, the Supreme Court, speaking through His Lordship Benin DSC held as follows. A court has no duty to call upon any party to testify in the case. The court acts as an umpire and only hears such evidence as the parties will prefer. Whether the parties will testify or not is none of the court's business. Indeed, for a court to insist that the party should testify would amount to the judge descending into the arena of conflict. After determining the tribal issues, the trial court leaves the field clear for the parties themselves to decide who will testify. We know of no law or rule which entitles a court to call upon a party to testify in the action. If such a law or rule does exist, we would venture to say that it is inapplicable under our legal dispensation. My Lord. So, my Lord, it's our submission that the petitioner has brought us to court. He has led evidence. He has closed his case. We do not think that there is anything more for us to say. It is our election. It is a risk we have taken. If indeed the petitioner has a good case, my lords, I believe that he should be dancing and be happy. It's a submission that the position that we have. I'm sorry. I withdraw it. My Lord, I withdraw it. My Lord, I finally submit that I refer the court also to the case of Presidential Election Petition, Special Edition. That's the first one. My Lords, the main judgment is reported in yes, my Lord, page 61 of the special edition of the Supreme Court of Ghana Law Reports, that's 2013. Lords, I refer your Lordships to page 217 and also to the judgment of Adina DSC on whom the burden of proof lies in the presidential petition. Therefore, the Lords, is our submission that our application that we made yesterday be upheld. No. Okay.
Do you intend to also?
Yes, my lords. My lords, we associate ourselves with the submissions made by Counsel for First Respondent, and in addition, we wish to refer your Lordships to the case of Joseph Akunu-Bafo and two others. This is Lawrence Buaku, Supreme Court of Ghana Law Reports.
Could you kindly spell Akunu-Bafo, Akunu for me?
Akunu is A-K-N-U-Bafo, B-A-F-F-O-E. And two others. This is
Lawrence Buaku. Supreme Court of Ghana Law Reports 2013. 56, where the court held referred to the Agbosu and others versus Kote and others, 2003, 2005, Ghana Law Reports as follows. A litigant who is a defendant in a civil case does not need to prove anything. The plaintiff who took the defendant to court has to prove what he claims he is entitled to from the defendant. At the same time, if the court has to make a determination of fact or of an issue, and that determination depends on evaluation of facts and evidence, the defendant must realize that the determination cannot be made on nothing. If the defendant desires the determination to be made in his favor, then he has the duty to help his cause or case by adducing before the court such facts or evidence that will induce the determination to be made in his favor. And this is the important section. The logical consequence to this is that if he lists no such facts or evidence, the court will be left with no choice but to evaluate the entire case on the basis of the evidence of the plaintiff. My Lord, so when we elect not to adduce evidence, we do so at our own risk and will fall on the sword if, after evaluating the evidence of the plaintiff or the petitioner in this case, the court comes to the conclusion that the plaintiff has met his burden of producing evidence and burden of proof. So, my lords, we believe that the petitioner ought to be very happy that the case will be determined on his evidence, including his evidence is chief and the evidence elicited from him during cross-examination. My lords,
but petitioner did not give evidence.
Yes, the witnesses
should be happy, but the petitioner
should be happy because his case, as advanced by his witnesses, is the matter before the court, together with evidence we have elicited from him, from the witnesses, in the course of cross-examination. So we think that our decision works in favor of the petitioner. And in any event, the petitioner cannot, by law, compel us to enter the witness box and adduce evidence. My lords, we would also wish to observe that the English case of Alexander versus Raisin, that counsel Raisin, R-A-I.
Arguments with so we are not opening the answers. So it should be discussed.
Yes, okay. Very well. Now, Alexander Raisin. Raisin is spelled R-A-I S-A-N S-O-N, sorry.
Unless you are abandoning your reference to it, you have to give us that citation.
My Lord, I can't immediately identify the citation. But my Lords, the main point we wish to make is that the English civil procedural rules make provision that the party that seeks to raise or notify the court that it does not intend to adduce evidence must do so timeously. And our point here is that in our rules, both CI 47 and CI 87, the drafters make no such requirement of the party. And indeed, to the extent that our CI 47 takes inspiration from the English Court Civil Procedural Rules of 1998, the fact that our drafters did not reproduce that text was an election not to be bound by that.
You haven't provided the text.
My Lord, the text
if you will not provide it.
Yes, my Lord. My Lord, the case of Alexander Raisin is reported in King's Bench Report 1936, Volume 1, at 169. 1936, my Lords. 169. And my Lords, since Alexander and Raisin, there have been various commentaries and decisions commenting on that decision. And my Lords, it is our submission that the English courts have currently moved to a position where they recognize that a submission of no case may be entertained. A submission of no case by a defendant may be entertained by the court, even in a situation where there's no jury. But my Lords, the significant point here is that for now, we have not indicated to the court that we'll be making a submission of no case. So those series of authorities cited in support of submission of no case, my Lord, will not apply. I do not think those authorities will apply in this situation. Our position and submission is that the petitioner has adduced evidence and closed his case. We have taken the position that in our assessment, they have not discharged the burden of proof and the burden of producing evidence, and therefore will not lead any further evidence. And the court will determine the case which has closed on the basis of the evidence before it. So, my lords, we are of the view, especially in the light of the provisions of CI 87, that we are entitled not to adduce any evidence. We are entitled not to call any witness, and all that the petitioner may do, if he so wishes, is to tender our witness statement as hearsay evidence. Unfortunately for the petitioner, he has closed his case, so he cannot even do that. Accordingly, we pray that our prayer to elect not to adduce evidence be upheld. We pray accordingly. My lords, it is our respectful submission that the first and the second respondents have in fact adduced evidence in this case. Now let's be perfectly clear. Let's be perfectly clear what we are seeing here, what we are dealing with here before our very eyes. The first respondent has put in a witness statement. And my Lord, I will first like to concentrate on the first respondent. And then at the end, I will make a few remarks about the second respondent, because I think the first respondent is at the heart of this case. So what is clearly before us is that the first respondent has put in a witness statement signed by its chairperson, Mrs. Gina Dukwe-Mensah, who is the returning officer, the constitutionally designated returning officer of the election, who also signed the constitutional instrument under which the election took place, CI 127, an instrument which places specific duties on her and her alone. She it was who also signed the answer to the petition on behalf of the first respondent. In respect of the answer, she signed an affidavit of verification. In respect of the witness statement, she signed a statement of truth. All these and more affidavits of Mrs. Gina Dukwe-Mensah that we shall refer to later in our submissions are before this court already. We invite your lordships to take judicial notice of Mrs. June Mensah's invocation of "to the glory of God" in making her declaration on 9th December 2020. Undoubtedly, she knows that the truth is what shall make you free. Yet, instead of coming into the witness box for the truth to make her free, her counsel is in fact saying to this court that she will not mount the witness box. Your lordships will note that counsel for the first respondent is not seeking to withdraw the answer of first respondent with affidavit of verification that has been sworn by the chairperson. counsel for the first respondent is not seeking to withdraw her witness statement either. In fact, I heard just a moment ago that it is being proposed that we should put it in by way of hearsay statement and all that. This has nothing to do with hearsay.
My lords, I never said they should put it in, with all due respect.
My lord, it is true that he didn't say we should. I believe he said we are entitled to or able to. So if I said should, let me correct myself out of deference to the correct language that he used. I believe it's true that he didn't say we should, but he said something to the effect that we are entitled to or we are able to put it in. He's giving us free legal advice, which, like free SHS, some people like, some people don't like so much. But anyway, my lords, the point that I just made by the side is that offer of free advice about tendering as hearsay is frankly is legally meaningless as far as we are concerned. So counsel for the first respondent is not seeking to withdraw a witness statement. Counsel is simply announcing at the end of the case for the petitioner that first respondent is not going to call the witness who had submitted a witness statement. That's the chairperson of first respondent who submitted a witness statement, who is a returning officer for the presidential election, and the constitutionality of whose declaration is at the heart of this case. Indeed, issue number 2 that your lordship set down for determination in the petition reads whether or not, based on the data contained in the declaration of the first respondent for my lord, there's some missing words from there's some missing words from
There is a little correction in the rendition.
Well, that is a certified true copy. So my lord, let me proceed, and we can later sort out what is missing. I think the point I'm making is quite clear, that the issue number 2, whose formulation will be clarified in due course, that issue relates to what was done in the declaration on the 9th of December. There's only been one declaration. That issue relates to that declaration, and eventually we may come back to the formulation of that. So it is the constitutionality of that declaration that is at the heart of this case, and that is reflected in issue number 2. And in our respectful submission, what is being put before you now is not only an affront to justice, but it is not in accordance with the rules of this court, and we respectfully submit it must not be countenanced by this court. Now, counsel seeks to rely on Order 36, Rule 4.3, and also CI 87, and then eventually the Evidence Act. And I wish to go through those provisions. CI 47, Order 36, which comes, as was rightly pointed out, it comes in a part of the rule, the order, which is headed Order of Speeches. And the head note, for what it's worth, says Order of Speeches. Rule 4.3 provides quite simply, where the defendant elects not to adduce evidence, where the defendant elects not to adduce evidence, the defendant may, after the close of the plaintiff's case, open the case of the defendant, and after the evidence on behalf of the defendant has been given, close the defendant's case, at the close of which the plaintiff may make a speech in reply. Now, my Lord, it is clear that in that provision, it goes beyond just order of speeches and so on, which is the point I was making yesterday. But yes, but my Lord, we are dealing with Order 36.4.3, and I'm submitting that if you look at the dispositive part of that Rule 4.3 makes it clear that that rule has nothing to do with what is being proposed before you. That Rule 4.3 is saying where the defendant elects not to adduce evidence, then whether or not the defendant has, in the course of cross-examination of a witness or the plaintiff or otherwise, put in a document, the plaintiff may, after the evidence on behalf of the plaintiff has been given, close the plaintiff's case. And the defendant may then state the case of the defendant. My Lord, that's all that provision says. The plaintiff may close, and the defendant may then state the case of the defendant. Now, my Lord, what this is dealing with in the context of a civil trial is obvious. What it is dealing with is that when we announce that we've closed the case, when we do that, this is saying that if the defendant elects not to adduce evidence, then in effect they come first in the order of address. That essentially is what this is doing. They come first in addressing the court about their case, so they may state the case. That's what this is dealing with.
Mr. Chikota, when you say they come first, you mean the plaintiff or the defendant comes first?
The defendant comes first.
Okay.
That is what this provision is saying. In the event that they elect not to adduce evidence. Now, my lords, this provision cannot be the pretext for what counsel for the first respondent seeks to do, namely preventing cross-examination of a witness who has already submitted a witness statement before this court. And that witness statement was submitted on the 22nd of January 2021, based on the orders of this court at the case management stage. It's our respectful submission that by filing its witness statement, the first respondent has clearly crossed the bridge as far as opening the witness up for cross-examination is concerned. That bridge has been crossed. That ship has already sailed. My lords,
in determining issues regarding leave for serving interrogatories on first respondent.
Please, Mr. Chikata, before you have referred us to Order 36, before you go on,
Yes, my lord.
I want you to read Order 38, Rule 3E, Sub-Rule 5 of CI 47 as amended by CI 87. That is in respect of written statements. Order 38, that is in respect of witness statements. Order 38, Rule 3E, Sub-Rule 5. You can read Sub-Rule 1 before you go and read Sub-Rule 5. Then you appreciate the import of the rule. Of CI 47 as amended by CI 87.
Yes. Order 38, Rule 1.
Rule 3E. Rule 3E 1 and 5. Rule 3E,
Yes.
Sub-Rule 1 and then Sub-Rule 5. That's the CI 87.
Yes. 3E1.
Yes.
If a party has served a witness statement and that party wishes to rely at the trial on the evidence of the witness who made the statement, that party shall call the witness to give oral evidence unless that party shall call the witness to give oral evidence. Shall. Unless the court otherwise orders. Unless the court orders otherwise. Or that party puts a statement in. That party puts it in as hearsay evidence. So in fact, it is that party. Yeah, but my lord, let's be just clear about what one says, because one does not advance anything as far as. But
You read 5 in addition so that.
Now 5 reads. 5 reads. If a party who, I'm sorry, is it 5 or 3F? 5. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. Now, my lords, this is why I was going to advert your minds to various statements made in affidavits of the chairperson of the first respondent in connection with that matter. And my lords, I believe that if you will allow me to proceed with the order of my submissions, I will explicitly address whatever concerns you have about CI 87 and its impact. Because, my lords, we're dealing with a situation here where in determining the issues regarding leave for serving interrogatories on the first respondent, the fact that what was in the interrogatories could be the subject of cross-examination was a critical aspect of what was urged on the court by first respondent. There was an affidavit filed on 22nd January 2021 by the chairperson in opposition to a motion for review of the court refusal to allow for interrogatories to be served. And this is what she says in paragraph 7. The applicant, referring to the applicant for review, the applicant does not suffer any injury at all to his rights. Paragraph 7. The applicant does not suffer any injury at all to his rights if the court dismisses the review application, as he still has the opportunity to solicit the answers he seeks during cross-examination if he so wishes. This is the chairperson in her affidavit, stating that the applicant does not suffer injury as he still has opportunity to solicit the answers he seeks during cross-examination if he so wishes. There is another affidavit on the 25th of January 2021 by the same chairperson, 25th of January 2021, by the same chairperson of the first respondent, in an affidavit in opposition to our motion for stay of proceedings. And there she states in paragraph 5 as follows: the petitioner does not suffer any injury at all to his rights if the court dismisses this application, as the petitioner will still have the opportunities to solicit the answers he seeks during cross-examination if he so wishes. These are statements of the chairperson who is now seeking to evade being cross-examined. And she puts, the first respondent puts it beyond doubt that she herself knew that cross-examination was imminent in terms of the processes of the court. So our submission is that the combination of the filing of the statement, so it is a combination of the filing of the statement and the clear statements in the affidavits that we have quoted from, that makes clear her own intimation to this court that she would be subjecting herself to cross-examination. That is clear in her own words, under her own hand. And my Lord,
Mr. Chikata, can't she change her mind?
Well, my Lord, there ought to be good reasons. There ought to be good reasons for changing her mind. And my Lord, indeed, my Lord, if she changes her mind, that should be openly put to this court, and the court may have power to disallow that change. Yes, my Lord, and I will, my Lord, if your Lordship will allow me to, because
are you implying that by this affirmance in the affidavit, she is stopped from saying that she will not give evidence? Is that your...
That is correct. That is correct. Yes. She has made representations to this court and to other parties in this case, specifically to the petitioner. She has made those representations, and she cannot now resign from those representations unless there's good reason. My Lord, I will come to the issue of where there is good reason for anything. The court, as your Lordship did when there was paragraphs 1 to 17, when it was obvious, where there is good reason for something to be done, of course the courts...
There was good reason there, but there is no good reason here.
That is what I'm submitting, because it has not even been put forward to you. In that particular case, the good reason was because the witness himself had noticed that there was a mistake in the statement of truth. The statement of truth is basically a format, from the solicitor's office. And the witness had signed the 1 to 32. He had not signed the statement of truth, but the statement of truth made a reference to paragraph 1 to. So I made an application for an amendment. So that is a completely different situation from what we have.
Mr. Speaker, 1 minute.
Yes.
Is there a reason why a witness should mount the witness box?
Yes, my Lord. There's a lot of reason.
Yes.
Especially when that witness is the declaring officer with a constitution.
I'm not even going down to the first respondent.
My Lord,
in this whole hearing, because witnesses filed statements, and we don't take them on the face of its value. They have to mount in the witness box swear an affidavit to the effect that swear an oath to the effect that what is contained in my witness statement, is the truth, until that is done. Otherwise, as soon as you file a witness statement, then you go on examining.
My lords, we're dealing with the specific circumstances of an election petition under the terms of CI 99, which your lordships have sometimes used to strike down the operation of CI 47.
And that this is a case that is different from all other cases.
Your lordships have said so. That's CI 99.
But what is there in CI 99 that suggests that witness statements automatically become statements on notes?
There is in fact nothing in CI 99 about witness statements, as your ladyship knows. There is nothing about witness statements. This is being imported from CI 47, and that's part of the issue that we're having.
And so that makes witness statements automatically statements on notes?
My lords, the tenor of the witness statement, as well as the answer in an election petition. My lord, in a normal statement of play in a high court, you don't have the plaintiff having to sign and having to verify in an affidavit. You don't have that.
But matrimonial petitions, yes, you do.
Yes.
This is just a different form, and that is replicated along the journey. Along the journey of commencing cases, some come in originating motions, some come in petitions, some come by writ. Each one has its character. That's all.
That's not all. Your lordships have said otherwise. Your lordships have said that an election petition under CI 99 has special characteristics, and that is part of.
Yeah. So, Mr. Kika, that changed the law on witness statements, because we know witness statements are potential evidence. Potential. That is why the statement of truth is there. So long as it is not sworn, it's not a sworn statement, it can't be evidence. My lord, judicial decisions are based on evidence. My lord, judicially taken, where the witness comes to the box and takes the oath.
My lord, this is why I'm drawing your attention to the difference in the election petition case, where the answer, the petition and the answer are signed. In this case, the chairperson signed the answer and signed a statement of an affidavit of verification. And not only that, she also signed the witness statement with a statement of truth.
As her potential evidence.
It's not potential.
It is, because it's not evidence.
My lord, it is not potential evidence, and I shall.
They are generic forms.
Very well.
Yes. It's evidence.
No,
if you look at
my lord, that's not what we need to. We ought to agree whether the filing of a witness statement means an election to adduce evidence. That's what we need to agree on. If it's an election to adduce evidence,
look at.
Is it an election? That's what we have to agree on.
Can you look at the 38 rule 3E2?
Now, my lords,
can you look at that? Can you look at that? So that
very well. It would have been useful for me to respond to what they provide.
No,
and then you can put. But very well. 38 rule 38
3E2.
3E2 rule the 38.
The same rules that by the two. The same rules that we were earlier on.
This is CI 87.
Yes.
Very well.
38 rule 3E sub 2.
Now this is your lordship is CI 87.
87, yes. 87.
And this is under general rule Is that it?
No.
Use a trial of witness statements.
It's witness statements. So let me read.
Page 4.
Where a witness is called to give oral evidence under sub rule 1, the witness statement of that witness shall stand as the evidence in chief of that witness unless the court otherwise orders.
Yes.
So it is only when the person is called upon to give evidence, then his witness statement becomes his evidence in chief.
My Lord,
The mere filing of a witness statement does not constitute evidence.
my lords, it constitutes an election to adduce evidence. It is an election to adduce evidence. And what we are dealing with, my lords, is very clear. Order 36, which they are relying on, it says where the defendant elects not to adduce evidence. And my submission has been that they elected by the witness statement, by the affidavits in which she said so, and I will put more affidavits of hers. So it is the election to adduce evidence.
Assuming we're not doing trial by witness statement, then the defendant comes to court.
My lords,
Mr. Chair, please. A defendant comes to court and he says that he's going to call, he himself is going to testify and call 5 witnesses. And at the end of plaintiff case, he decided that, my Lord, I'm not going to lead evidence. Neither am I going to call witnesses. My Lord, would he be barred from saying so? Because he had initially informed the court that he himself was going to testify and call 5 witnesses.
my lords, that is why I said that it depends on the context. In this case, we're dealing with the context of an election petition with its characteristics, and we are saying respectfully that in the context of the election petition,
Yes.
where the petitioner has put in a petition, the petitioner has put in a statement of verification, an affidavit of verification.
Yes.
You have the answer, and this chairperson signs the answer on behalf of the first respondent. And after signing that, she also signs a number of affidavits.
So, Mr. Chikata,
And so,
the petitioner in this case has signed a petition.
yes,
Can he be compelled to come and give evidence?
my
The
lord,
petitioner.
who compel him?
He has almost deposed. He has almost deposed to all the affidavits from
But
your
my lord,
side.
that is not the point. Who is going to compel him?
What is good for the petitioner issued the
Petitioner has
petition?
not filed a witness statement.
No, but
Has the petitioner
he
filed a witness
he has
statement?
filed a petition. He has deposed to several affidavits. Can we compel him?
The petitioner has not filed a witness statement.
What is more great than a petition?
Orders.
Mr. Gita, what is more great? What is more serious than a pleading and a witness?
My lord, it's not a question of what is more serious. It's a question of what the rules.
No,
the rules says where the defendant elects not to adduce
Yes, but I'm
evidence.
saying that you are addressing us. You've referred to several affidavits imposed by
Yes.
the chairperson or the first respondent. And I'm
Showing
saying
that-
that, Mr. Kita, I'm saying that in the same vein, the petitioner has deposed to several affidavits before us, but we cannot compel him.
In
to come and give
no
evidence.
affidavit of the petitioner that she say what I'm going to be subjecting myself to cross-examination, and therefore you don't need to send me interrogatories. Nowhere has she done that. The petitioner.
I'd like to say, Mr. Chikata.
Well, can I answer one at a time?
Very well, very well, very well.
Yes, my lord, the petitioner has nowhere said that I am going to present myself to cross-examination and then reside on that. The petitioner has never said that. In fact, the petitioner has not filed a witness statement. The petitioner is relying on his witnesses, which is entirely allowed. So, my lord, nobody can compel him to come and testify. And what the point that I was making in respect of what is in the affidavits of this chairperson is that she herself, in opposing an application in respect of serving on her interrogatories, she deposes to the fact that she is in fact going to be available to be cross-examined. She says that. I read the affidavit. There's nothing equivalent to that in the affidavits of the petitioner. Nothing. And there cannot be a legitimate comparison between the status of the petitioner and the status of the chairperson on the basis of that. That cannot happen. The logic of the situation should compel us to only one conclusion. The affidavits that I'm reading, and I will read some more affidavits of hers before I'm done, those affidavits state clearly her disposition to be cross-examined. And she uses that as a basis for opposing the leave for interrogatory application. She uses that. So you can't discount that. And nothing that the petitioner has done in an affidavit, nothing compares to that.
So, Mr. Secretary, all that I'm saying is this. If a party comes to court and informs the court that he's going to give evidence himself and contrary witnesses, and later on he changes his mind, that's because of certain things that are happening. I don't intend to lead evidence, neither do I intend to call witnesses. Is the party bound, or can the court compel that because of the statement that my lord, can he be compelled to testify?
My lords, what I've stated clearly is that Order 36, Rule 4.3 is clear in its terms. Where the defendant elects not to adduce evidence, and so and so. And my lord, I have said that in this case, this respondent, this first respondent, has elected, and he's elected both by filing the witness statement, and also he is elected by her affidavit, in which she was rejecting our request for certain information to be provided by her, and she was in effect saying to us, wait, when I'm being cross-examined, you can put it to me. That's the effect of what she said in her affidavits. That's the effect.
So you can't change his mind.
My lord, that's why I said if she changes her mind, there are proper ways to effect that. At the moment, we do not have that situation. And my lords, I will respectfully further indicate that the dispositive part of Order 26, Rule 4.3 has nothing to do with what is being done before you. That dispositive part just says the plaintiff may, after the evidence on behalf of the plaintiff has been given, close the plaintiff's case, and the defendant may then state the case of the defendant. That's the dispositive part. It has nothing to do with what has been done.
My brother on my right referred you earlier on to Order 38, Rule 3E5, which deals specifically with witness statements. See how it is? Which deals with specifically with witness statements. And an interpretation that we can put on is that witness statement.
Yes, my lord, the file.
So the witness has gone to the witness box and taken the judicial oath.
My lord, with respect, that is an erroneous interpretation.
No.
With respect, what that rule reads, if a party who has served a witness statement does not call the witness to give evidence at the trial, or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay. So the dispositive part of that is any other party may put the witness statement in as hearsay evidence. That's the dispositive part.
So it allows the party not to call a witness to have filed a witness statement.
No, my lords, that cannot be the proper interpretation. It says, if a party, my lord, it says, if a party who has served the witness statement does not call the witness to give, yes. My lord, my lord.
And please, Mr. Chikata, in your wits, relief 4, the number of witnesses that the petitioner intends to call, 5. Eventually you call 2, and then you, with leave of the court, you add 1. But were you going to insist that because you've written in your writ that you will call 5 witnesses, go and bring the 5 witnesses.
My lords, that is not the same thing. We have not filed 5 witness statements. We have not filed 5 witness. My lord, the matter is very clear. We had not filed 5 witness statements. So that analogy does not hold.
But I've already told you that yes, the witness statement can be filed, but until the witness enter into the witness box and swear an oath, it is not evidence yet.
My lords, this is not a position that was taken by this Supreme Court in a case Sumaila Bilbil versus Adamu Dramani and the Attorney General. That position that your leadership has expressed was not the position taken. May I? It is, as far as I know, it's unreported. It's written number J.
It's reported.
Very well. I don't have the report, but I have the ruling.
I think 20,
My lord, may I read from? May I read? Yes, but my lord, may I read and then we can discuss what the impact of CI7 is on that matter.
Okay, so
read number J1/2/2010. The ruling is delivered on 2010. Yes, my lord, it's 2012 1 Supreme Court of Ghana law reports at 370. And my lords, I'm well aware that CI 87 was not enforced at that time, but CI 47 was enforced. And my lord, the portion of his lordship justice and my lords, it was a panel that consisted of Dr. Datseban, Justice of the Supreme Court, Ansa Adinya Owusu, Miss Doche Yeboah JSC, as your lordship then was, as you were then, Bafo Boni JSC, Badegbe, and Akuto Bamfu. And my lords, this is what, no, that's not No. Well, there are a series of these cases. That report, the law report that I refer to refers to another of the Bilbil cases. As your lordship knows, there's a series of. So, my lord, let me stick with my writ number J1/2/2010, a decision delivered on the 23rd of May 2012. And in that, this is what Doctor.
The citation is 370.
So the citation is 374 rather than 370. If we're taking it from the Supreme 174 2012. And this is what Dr. Datseban says in the ruling of the court, which included your lordship, the Chief Justice. It is a unanimous view of this court that the first defendant, Adamu Dramani, should be called upon to open his defense in the interest of justice. This case does not have the ordinary characteristics of a trial, say at the High Court. The procedure before this court is such that before the commencement of oral testimony in this case, the first defendant had already put matters in evidence by affidavit. In this circumstance, it is artificial and hardly sustainable to disregard the evidence already adduced by the affidavit of the first respondent and proceed to an assessment of a no-case submission made on his behalf as if the only evidence on record is that of the plaintiff. So, my lord,
Mr. Chigata, please. We are dealing with witness statement, which is not sworn. You are talking about an affidavit that is sworn.
and I refer to
So it's affidavit evidence.
I refer
Witness statement cannot be evidence. That is where we depart.
my lords,
Affidavit is evidence because it is sworn. But before the commission of oath,
my lords, in
witness statements are not sworn.
my lords, in this case, well, witness statements are also verified as documents of truth. Yes, but my Lord,
that is why we allow you.
My Lord, yes, but my Lord, I refer to affidavits sworn to by the chairperson. I refer to affidavits. No, but my Lord, the ruling of this court.
The issue between you and me in particular is that, as far as for me, we take the judicial oath, the oath to speak the truth. For him, for her to be cross-examined, for the witness statement to be adapted as evidence in chief. That document is just a potential evidence. It is not proper evidence before this court because it's not an oath.
My Lord,
that on it.
My Lord, that evidence indicates an election to adduce evidence. My Lord, that is what I'm submitting.
So it is evidence.
It's an election. My Lord, I'm saying that
okay.
The rule that we're dealing with talks about election to adduce evidence. And I'm saying it's an election to adduce evidence. So my Lord cannot keep going back to the issue of whether it has been sworn or not, because the order that we are dealing with, according to the argument of counsel for the first respondent, is an order where he is reading where the defendant elects not to adduce evidence. That is the material basis on which he is putting forward his submissions to you. And your lordships are taking me away from the language of that order where you elect to adduce evidence, and your lordships are going into an issue of where he has called the evidence. But those are two different scenarios. Because if he has elected by virtue of the witness statement and affidavits that he has filed, if he has clearly elected, then that order 26.43 cannot apply because of his election. That's the point I'm making. So the dispositive part of 36.43, that dispositive part, will not come into operation. And I'm saying further that in any case, that dispositive part of that order 36.43 does not have the consequence that he's attributing to it. And I'm further submitting that all these questions about whether this particular witness statement, or whether in general terms the witness statement means that he cannot change his mind or not, all those do not address what the terms of Order 36 are. Because Order 36 is talking about electing not to adduce evidence. Electing not to adduce.
May I seek a clarification, and maybe it will help us to move forward. So, if I understand your submission, it is that an election has to be made by the party. Mm-hmm. Now, your submission is that the first respondent made this election from when they filed the answer and other affidavits that they have introduced, and that. So is for you
the witness statement.
Yes, the witness statement. Can I then say that the key issue is what constitutes the election, and at what time can it be made?
Absolutely.
And can what the first respondent is doing now constitute an election now rather than the previous thing? That seems to me to be the issue that we have.
I agree 100% that is the issue before us. And my Lord, what I'm submitting is that as at the time when this application was put before you yesterday, as at that time, the election that had been made was contrary to that precondition in Order 36, Rule 4.3. Because that condition said, where the defendant elects not to adduce evidence. And by that time, when he got up to say what he said, they had already elected to adduce evidence. That is my submission. That is, well, my lord, that is determination has been made on facts. And the facts that are before all of us in plain view are that they have filed a witness statement, the chairperson, and she has filed various affidavits in which she says she is offering herself for cross-examination basically on the assumption, and not an assumption, she's actually saying, I don't want to have to answer interrogatories because I'm available for cross-examination. That's what she's saying. And I'm saying that affidavit upon affidavit which deposes to that. Affidavit upon affidavit which deposes to that constitute representations of her election to testify, her election to undergo cross-examination. That is my submission. Yes.
The point I needed or wanted to you to address is the point at which here witness statements are filed. It is done at the case management stage, when the court directs that parties should file their witness statements. This case management stage is a process for ensuring that the case can move expeditiously. Is that not the situation? So, with that direction, following that, no party can change their mind?
Well, they can ask for leave to. They can ask for leave where they need to change their mind. They can ask for leave.
Thank you.
In this case, we do not have an application for leave. In this case, prior to what was represented to you yesterday, as at the time that my learned friend got up to make his submissions, as at that time, my submission is that there had been an election to do the opposite of the precondition in Order 36, Rule 4.3, where the defendant elects not to adduce evidence. And respectfully, all the material that is before this court in plain view, as I indicated, all the material is that there was an election to testify. There was an election to adduce evidence. And that was also included. That was also included. That's it. That election. Page. My lords, another significant passage in the decision in Biel and Dramani is a passage at page 377 where, after referring to the English authorities, including Alexander and Reagan, can I have back my... Yeah, okay. Yeah, okay. Where, after referring to Alexander and Rayson, in particular the passage where the court had said that it is not right that the judge of fact should be asked to express any opinion upon the evidence until the evidence is completed. His Lordship Justice Dr. Barr continues, similarly, it is an inherently difficult exercise to ask this court, in this case, to disregard evidence put in place by the first defendant's affidavit and to rule on his submission of no case as if the only evidence on record is that of the plaintiff. That is why we consider that the interest of justice would be best served by hearing whatever evidence the first defendant wishes to offer in his defense. The interest of justice would be best served by hearing whatever evidence the first defendant wishes to offer in his defense. This court can then make up its mind in relation to all the facts at the end of the trial. My lords, respectfully, this wisdom of His Lordship Justice Jataban is particularly germane to this case, where it is the chairperson of the Electoral Commission who is not only the returning officer, but in whose bosom resides the basis on which she made her declaration. It is in nobody else's bosom, not even in the bosom of your lordships. It's the law that is in your bosom, but in respect of the declaration, your lordships, it is only in her bosom that the basis of the declaration can be found. And so, where she has elected to give evidence before you, we cannot have a misapplication of Order 36, Rule 4.3 as a reason for her not doing what she has told us in a sworn affidavit she's ready to do. She cannot do that. The God to whose glory she announced she was doing what she was doing is a God of truth. And therefore, my lords, it is important to bear in mind what Justice Dr. Barr said. And in this particular case, he actually goes on to cite what he calls the sound advice of Lord Justice Simon Brown in the Benham case cited above, where he says, "Let me state my central conclusion as emphatically as I can. Rarely, if ever, should a judge trying a civil action without a jury entertain a submission of no case to answer. That clearly was the court's conclusion in Alexander and Rayson, and I see no reason to take a different view today. The CPR notwithstanding, almost without, and that is a reference to the CPR, of course, in England, almost without exception, the dangers and difficulties involved will outweigh any supposed advantages. Any temptation, that's the last word, any temptation to entertain a submission should almost invariably be resisted. Now, my lords, it is therefore my submission the lordships are comparing. My lords, my respectful submission is that exactly as in the Bill decision of the Supreme Court, the interests of justice at a minimum required this court to do exactly what was done in the Bill case.
Sorry for interrupting your submission. In that case, if my memory serves me right, we have come to court and made a submission of no case. And what we read was a ruling. In this case,
there is no submission of
yes, they are opting. It's an option. They are electing not to give evidence. So let us be very clear.
Yes, my lords. My lords, I'm very clear in my mind about what happened in the Bill case. I'm very clear in my mind about that. And I'm very clear in my mind that in that case, the plaintiff went to court seeking an enforcement of a provision of the Constitution in respect of the eligibility, exactly, the eligibility of an MP. Parliament. Yes. And my lords, in that case, as your lordship rightly said, there was a submission of no case. But my lords, the reasoning, the ratio decidendi of that case, in my respectful submission, is based on what the interests of justice require, where a plaintiff has deposed to an affidavit, and in that case it was only one affidavit, and their lordships were saying, their lordships including your lordship the Chief Justice, said clearly in that case that in the interest of justice the defendant should testify. That's what your lordship said, and I'm respectfully submitting that that ratio is a ratio that is worth applying in the circumstances of this case. The only difference in the circumstances of this case is that they are relying on Order 36 Rule 4.3. And in my submission, that Order 36 Rule 4.3 does not lead to what they are asking for, because...
Please, I want to correct this. They are relying on Order 36 and Order 38. Please don't leave Order 38 out, because Order 36 has nothing to do with witness statements. Order 38 is specifically crafted for witness statements. And you are avoiding that.
My lords, I'm not avoiding that. My lords, if your lordships are with me that Order 36, Rule 4.3 is irrelevant, then, my lords, I will indeed address directly what your lordship is claiming that I'm avoiding. I cannot be said to be avoiding it when I referred your lordships to that Rule 5, and I said respectfully that the interpretation that your lordship was putting on that was not. I believe I responded to that. So how can your lordship on the other side say that I didn't respond, I'm avoiding 38.5? I responded to your lordship directly. My lords, I don't think it's fair to me to be making that sort of observation.
Another significant difference.
But my lord, can my position be accepted that I responded to
yes,
your
lordship? You did.
Yes. So how can my lord say that I'm avoiding a particular provision? So that's not right.
I just want to draw your mind. Another significant difference in the case we cited, the bill case, is that dealt with affidavits. That dealt with affidavits. The court dealt with affidavits, which are generally evidence, because they are sworn. But in this case, we are not dealing with affidavit. So that is another significant difference.
My lord,
I wanted to...
My lords, with the greatest respect, that is why I took the pains to refer to affidavits that are before you in these proceedings. In the same way as an affidavit was before the court in those proceedings, I have referred your lordships to affidavits which are before you in these proceedings.
But these affidavits attached to applications.
Yes, but they are still before you. They are still before the court. My lords, I mean, affidavits attached to applications are before the court. Is that not interlocutory? That is why when people say affidavit, they say I refer to all the processes as if I included them in the affidavit. I mean, that is, I would have thought, the basic aspect of
in writing a judgment, in writing a judgment or a ruling,
yes,
would a judge be right if the judge went referring to affidavits attached to applications and left the record of the testimonies and the cross-examinations that the judge received? Would you, in writing a judgment, would a judge be right, ever right, in referring to affidavits attached to applications that have been completed?
Yes, my lord, the judge, I not ignore. I never said that you should ignore. I said that you can refer to those affidavits. My answer to your specific, my lady, is that you can, for instance, if something that was in testimony is contradicted by something that she filed in affidavit on oath, that is a matter that can be referred to, and that is a matter indeed upon which there can be cross-examination. There can be cross-examination on those matters.
That's mixing. That's totally mixing.
Totally what?
Mixing. If you have interlocutory applications and they're done with, you can mix them with the evidence taken at trial. You know that.
It's not a question of mixing them. You always have available a record. And if in that record there are affidavits in which statements have been made, they are on oath, and you are entitled to refer to them. That's exactly what the lordships did. In that Bill case, it had not got to the, what was stated in the affidavit has not been stated in the witness box. What was stated in the affidavit had not been stated in the witness box.
It's a trial on affidavits. In the Bill case, trial on affidavits.
Yes, but that's what
so they were perfectly right. My laws were perfectly right.
But is your lordship saying that if the witness had gone into the witness box and had said something contrary to what they said in the affidavit, for instance, if the court had ordered that we want to hear you, just as the court ordered the defendant to go into the witness box. The court could have said, we want to hear your evidence in the witness box. Is your lordship saying that you cannot refer to that affidavit which is deposed?
No, even in the affidavit trial, a deponent can be ordered to appear, to be cross-examined. So it's a trial.
That's what happened. But that is what happened.
Because that affidavit is evidence. So you can be cross-examined on it. But we are saying that in a witness statement, it is not yet evidence. That is where
my lords, I don't think the issue that we are dealing with right now should really be the issue of whether it is yet evidence, because I believe
yes, that is agitating my mind. That is what is agitating my mind. But whether it is evidence or not, and the mere fact
that order 34 as cited by counsel is not relevant in the current circumstances. That's what you're saying.
Is that what your ladyship is saying?
No, that's what I understand you are saying.
That's what I've been saying.
Order 36.
And I believe that is what was summarized by your...
Realize different members of the bench are agitated by different things.
Absolutely. And I'm seeking to address the different things.
Yeah.
And I appreciate the fact that your lordships are candid with your concerns. I appreciate that entirely. And so, my lords, the point I'm making, if we move away from Order 36-04-3, if we move from there into the question of what is the effect of a witness statement, which is what is agitating your lordship's mind. What is the effect of a witness statement prior to when the witness actually goes into the witness box? And my lords, my submission on this is very straightforward. My submission on this is that your lordships made case management orders in this case in respect of how the case would proceed, including the witness statements and the witnesses. Now, my lords, it is my respectful submission that nowhere in either your case management orders or in CI 99, nowhere is there provision made for the procedure that my learned friends are seeking to adopt. Nowhere in the rules. Nowhere in the rules. Now, your lordships have been referring to Order 38-3 as amended in CI 87. And in that order, 38 rule 3E, the provision again is very clear. If a party has served a witness statement and that party wishes to rely at the trial on the evidence of the witness who made the statement, that party shall call the witness if you wish to rely. That is why in my opening words, I said to your lordships, in my opening words, I said respectfully to your lordships, in my opening words, I said, this is not a situation in which counsel is seeking to withdraw the witness statement. I said that in my opening words. This is not a situation in which counsel is saying, I am no more relying on my witness statement or my answer. And 38-3E says, if you are still wishing to rely at the trial on the evidence of the witness who made the statement, you shall call the witness. Mandatory terms. Mandatory. You shall call the witness. They have not said they are not relying on that witness statement. They have not said that. So, shall call is mandatory the last time I checked in the law books. And my lords, I'm sorry.
The lie, as you read.
Yes, but my lords, as that now, nobody has said we don't intend to rely on the witness statement. Nowhere has it been stated. All they have said is that we are not doing. My lord, that is the reality. I mean, however much grumbling goes on the other side, the reality is that ethics at the bar. Counsel is on his feet. He is addressing the bench. Please, please, please. You may take notes. You may hear him, but you don't have to make a noise at the background. Please, please, please. So, my lord, I mean, if they do not intend to rely on the witness statement, they should say so. It's as simple as that. If they do not intend to rely on the witness statement. Because, my lord, yes, my lord, but this is important. My lord, this is important because there are many options open to us. If they say they are not relying on the witness, we can apply to the court for a subpoena to call the chairperson. For instance, we can apply to the court, yes, because
I thought it is implied.
the only reason why we did not take that course is of course because she is acting on behalf of the first respondent. So it would be inappropriate to issue a subpoena on the opposite party whom she is representing.
I thought it was implied by the application, by the nature of the application. I thought it was implied that you do not want to rely on the...
As your lordships heard me, from the opening paragraph or the opening sentences of my submission, I indicated what my understanding of what they had done was based on Order 36, based on... And I did not hear, and I don't think that your lordships heard any differently, I did not hear at any point a statement that they had decided not to rely on the evidence of the witness. I did not hear that at any point. And my submission is that unless they give an indication, and if they give that indication, then there are other consequences, especially in terms of our case. Because once they give that indication, then it is open for us, for instance, to have her subpoenaed to testify. As a public officer who holds certain records, it is open to us to do that. And my lords, this will not be contrary to any human rights of hers, because she has a constitutional duty that she is performing, and if she is called upon by a court to come and testify to the performance of that constitutional duty, that cannot be contrary to any human right. In any case, if, for example, there was an attempt to suggest that the witness had some privilege, or wants to exercise a right to avoid self-incrimination, for instance, if the witness would have to give that indication. It cannot be assumed for her by anybody, least of all from the bench. It cannot be assumed that the witness has certain rights against self-incrimination, for instance, which she is wishing to exercise. Those are indeed human rights provisions, especially applicable in a criminal trial context. But whether or not they are applicable here, the witness is the one who has to invoke that particular claim of a privilege or right against self-incrimination or whatever. And that has not, as we speak, been the case that is before you. What is before you is Order 36, Rule 4, Order 38, Rule 3E and 5. I just read 3E, and clearly in my submission, until we have an indication that they do not intend to rely on that witness statement, and they then take the consequences of that, including consequences of what we are then able to do in terms of asking the court. The court may refuse it, but it would be entirely open to us to ask the court to take certain steps on account of what she said or what council says they are going to do. It is entirely open to her to take those steps after there is, if indeed that is the indication that is being given. Then I believe Order 38, Rule 3E5, I have addressed previously. So unless there is a specific question about any aspect of Order 38 that I'm not avoiding, so I'm happy to have my attention drawn to any other aspect that I've not covered. But I believe I have covered all aspects of Order 38 for 1B. Order 38, 3E and 5. Now, my lords, as I've indicated, and I believe there was a question from the bench yesterday about whether these are not issues of human rights. And I have an answer today. My lords, you put that into the arena yesterday, and so it's useful that I make a specific.
With all due respect. Yeah.
My lords, I'm not ignoring what your lordship say. I'm not using that.
No, yesterday
I have a very well. Yes. Now, my lords, it is therefore my respectful submission that require what the clear interests of justice require is for your lordships not to allow the evasion by the chairperson from cross-examination. And my lords, this is particularly important because of the nature of the function of this particular witness. We are not dealing with a witness in a normal civil trial, where it is simply a matter of competing private interests. We're not dealing with that situation. We're dealing with a matter concerning the exercise of grave constitutional responsibilities by someone who has been duly appointed to a high office of state. And that person, in my respectful submission, has a constitutional duty that person, in my respectful submission, has a constitutional duty to give an account of what she has done in the conduct of her responsibilities. Now, my lords, the particular responsibility that she is carrying out and for which she needs to give an account, the particular responsibility here is no less than the responsibility to to declare who has, in accordance with the will of the people, been elected the president of Ghana. That is no mean duty. That is a duty That is a duty in respect of which this petition has been brought. And as I indicated, the issue 2 that your lordships have set down, that issue 2 speaks to the proper conduct of her responsibilities in making a declaration. And this petition is about her own declaration, which we all watched. At least we watched a part of it. And the petition is based on what she said. There has been no other declaration. And your lordships will note that in the affidavit, in the affidavit again, it's an affidavit that she filed in opposition to a motion on notice for leave to inspect documents, which was another application that we brought. In that affidavit, she states, among other things, in fact, from paragraph 8 of that affidavit, she says, Form 13 is generated from the summation of all the results in the Presidential Regional Results Summary Sheet, Form 12. The petitioner has duplicate copies of the Presidential Results Summary Sheet, Form 12, as admitted by the 2 witnesses of the petitioner. Then paragraph 9, Form 13B was generated by the first respondent to aid the declaration of results. So, my lords, she is testifying in this affidavit to a number of important facts about what she did. Form 13B was generated by the first respondent to aid the declaration of results obtained by all the candidates by aggregating the results from the Presidential Regional Results Summary Sheet Form 12 for the 16 regions in a way that does not materially affect the form substance and not calculated to mislead any person. Now, my lords, she goes on to say that apart from Form 13, yes, in paragraph 7, she says, I say that save for Forms 13 and 13B, which is attached to my witness statement filed on 22nd January 2021 as Exhibit 4, the petitioner already has in his possession, custody or power, duplicate copies of all the other forms and documents he is requesting to inspect, as same were given to him by his agents at the various courts. So the chairperson on behalf of the first respondent, is acknowledging that save for Form 13 and 13B, which is attached to the witness statement, petitioner already has certain things in the possession, and she even seeks to quote. But that Form 13B is a critical form for the exercise of her responsibilities, and she has to speak to that form. Indeed, your lordships heard testimony from the second witness of the petitioner to the effect that what was being claimed as Form 13 is not in compliance with what is in CI 127. The second witness of the petitioner stated that very categorically, that what was being offered as Form 13 was not compliant with the form that is Form 13 in CI 127. CI 127 is under the hand of the chairperson of the Electoral Commission. And there is evidence before your lordships that she did not even comply with the CI under her own hand. My lords, if the holder of such a public office cannot be held to account by being cross-examined after she herself has given a witness statement, then, my lords, with the greatest respect, we would be posing grave dangers to the Republic. Because the holders of important offices can shield themselves from accountability by saying in every case that we will not allow ourselves to be cross-examined and nobody can do anything about it. And what I submitted earlier, and which ties into this point that I'm making, is that if it were not for the fact that she is the representative who has sworn a witness statement on behalf of the first respondent, it would be open to us to ask the court for a subpoena to have her testify. So, my lords, we respectfully submit that in the circumstances that we are faced with here, with this particular holder of this particularly singular office that is supposed to make a determination that reflects the sovereign will of the voters of Ghana in an election, which is what democracy is all about. It is our respectful submission that that constitutional obligation cannot be set aside by subsidiary legislation or by reliance on subsidiary legislation. It cannot. Every legislation that we've talked about, CI 87, CI 47, and I mean, none of that can set aside the sacred public duty of this chairperson and the need to account for that public duty where the forum demands it. And my lords, this is a forum that demands it. My lords, reference has been made by my learned friend to the case of Armour versus Hydrofoam. And that was indeed a Supreme Court decision in 2012, the decision read by Justice Baining and a court that comprised various justices, including your Lordship, the Chief Justice. Now, my Lord, that case has absolutely no application to the circumstances that we are dealing with. Because in that case, what happened was that the parties had agreed that instead of testifying by themselves, they would both rely on the testimony of an expert, a surveyor. And on appeal, the point was raised that the plaintiff himself ought to have testified and not rely on the evidence of the expert. Within that context, the parties had agreed that we're going to rely on an expert because this is a matter on which an expert can resolve the issue between us. We don't need to be sort of testifying and, we are not the expert. We'll rely on an expert. The parties had agreed that. Then they go to court, and one party is more or less arguing that because the plaintiff did not testify, it should be held against him. My lords, of course, rejected that argument, and my lords made it clear that you can't compel a party to a suit to testify. That has nothing to do with the situation that we're dealing with here. And the court said in Baining's judgment, page 1563 to 1564, in the instant case, the issue agreed upon was the value of the land. The trial judge considered it required expert evidence to assist him to determine it. The parties appear to have agreed with that position taken by the trial judge. For apart from the fact that they did not challenge it, neither of them gave evidence by themselves. They all deferred to expert evidence. The plaintiff relied on the evidence of the expert nominated and appointed by the court with the parties' consent. The defendant went further to call three other experts in land valuation. It is in that context that the Lordship said a party does not need to call evidence by himself. Where the issue to be resolved is of such a nature that expert evidence would, I think it should be B, but here it says would the best evidence. I think B is missing from the report. Expert evidence would be the best evidence required to assist the tribunal of fact to resolve the issue, or where expert evidence is dispositive of the issue. That is what hydrophone's case, Armour and hydrophone, is about. That case has no application to the circumstances that we're dealing with here. The circumstances that we're dealing with here is of somebody who has elected to testify and who has notified of that election not only by submitting a witness statement but also in affidavits that he has filed. Because, my lord, if we didn't take her affidavit seriously, then it would almost be as if she is taunting us and saying, I am prepared to give evidence. She's taunting us with that, and she's using that to get a decision in her favor on interrogatories. Once that decision is given, then she now says, no more, I'm not giving evidence. You said in opposition to an application for leave for interrogatories, you, the holder of that important constitutional office, you said, I'm going to be available to be cross-examined. On that basis, among other things, their lordships have made a ruling allowing you not to have to answer interrogatories. Then, after you've got that decision, you now ignore the things that you said in your affidavits, and you come and your counsel is saying to the court, I'm not going to put you in the witness box. obviously, the interrogatories process that we filed was meant to help us in the conduct of our case. And what they filed by way of witness statements and so on was again meant to help us in the conduct of our case. So once they filed and gave an indication that she was going to testify, and she herself gave that indication in her affidavits, my lords, our options in terms of her being called to account for a constitutional duty, our options were entirely non-existent. Our options were to calmly wait for her to come into the witness box for cross-examination. We had no other option. We had no other option, and we still have no other option, because it has not been said at any point to your lordships that they are not relying on that witness statement. It has not been said. Now, my lords, another decision was cited, I believe. Yes, this is the Akunu, Bafo, and Lawrence Boaku case. And my lords, part of the problem that I see in respect of what we are faced with is that on the one hand, they are saying that they are not making a submission of no case. Then on the other hand, they are talking about burden of proof. My lord, the burden of proof can only be relevant if we are talking about a submission of no case. Because otherwise, why are we discussing burden of proof? I mean, burden of proof has no relevance at this point. If all we are talking about is Order 36, Rule 4.3, and so on, burden of proof has absolutely no relevance. In any case, the authority that was cited, this Joseph, Aknu, Bafo, and Lawrence Boaku, significantly, when counsel himself was reading from the passage that he read from, the lordships talked about the shifting of the evidential burden. The shifting of the burden, which depends on the stage that the case is at. And my lords, I'm really reluctant to go into the issue of burden of proof at this point, because I think it's irrelevant. But because it has been raised, I'm obliged to point out why it is irrelevant. Because if your lordships look at the Evidence Act from Section 10, and my lords, I will not read those sections, but from Section 10 to Section 15, your lordships will see the differentiation between the burden of persuasion, the burden of adducing evidence. And my lords will know that in a case, the burden of proof can shift depending on this stage and depending on another stage. So if indeed they were making a submission of no case and we were having to respond, then we would, for instance, be able to demonstrate that as at where we are, you have to take the petitioner's case as true. You have to take the evidence of the petitioner as it is, without the benefit of the answer and whatever is going to be testified to by the DD. So if we were dealing with that matter in the context of a submission of no case, I would have clarity on how I would address your lordships on burden of proof. But they are saying to us that they are not dealing with burden of, they are not dealing with they're not dealing with a submission of no case. And I believe your lordships have accepted that that is their position. Now, if that is their position, then my simple submission is that burden of proof has no relevance at this stage. And that what we should simply focus on at this stage is, if they decide to do a submission of no case later, that's another step. We'll cross that bridge when we get there. I never like to cross bridges before I get there. But my lords, at this stage, we are not dealing with matters of burden of proof. And so when we also have read to your lordships section 62(1). At the trial of an action, a witness can testify only if he is subject to the examination of all parties to the action, if they choose to attend and examine. If a witness who has testified is not available to be examined by all the parties to the action who choose to attend and examine, and the unavailability of the witness has not been caused by any party who seeks to cross-examine the witness, the court may in its discretion exclude the entire testimony or any part of the testimony as fairness requires. This is clearly a section that has nothing to do with why we're here. Because
I thought the court pointed this out and counsel accepted it. So let's
I did not have the impression that counsel accepted, because after the court made the reference, he made a further reference to section 60, because that's why he went on to say we do not require any further evidence in this matter. He went on in my notes, unless I didn't hear him. And that is what led him also to the citation of the cases that he sought to. Now, my lords, there's been a suggestion petitioner cannot compel us to enter the witness box. My lords, we are not actually compelling. It is indeed their election. And we are saying that they have made the election. So it is not our compelling them, but they have made the election and they must stand by it unless they clearly and unreservedly give a contrary indication. Now, my lords, it was also suggested that, this was by reference to the English civil procedure rules. It was also suggested that the drafters of the drafters of CI 41 and CI 87 made some choices differently from the English civil procedure rules. Of course, we are a sovereign country and our statutory regulations are made by our own rules of court committee and so on and so forth. But my lords, we cannot put English civil procedure rules against our rules and say that our rules of court committee drew inspiration from this, and we try to compare the two and say that therefore we should interpret ours differently. My lord, that respectfully is not an appropriate way to interpret our own rules. Our rules, CI 47 and 87, as I have gone through, our rules make provision for what they make provision for. And you cannot come and say that the word timeously does not appear in our rules. It appears in the English rules, and therefore there was a reason why they did not include timeously in our rules. My lords, that with the greatest respect, is not a process that your lordships should use for interpreting our subsidiary legislation. Our subsidiary legislation is in its own terms, and I have read the terms of that subsidiary legislation and their applicability here. So nothing in those English rules, nothing can be relevant. And indeed, it is also my submission. It is also my submission that, in fact, as I indicated even yesterday, it's also my submission that in this particular matter of an election petition, it has not been demonstrated that what they seek to do is in compliance with CI 99 or CI 47 or CI 87. It has not been demonstrated that there is compliance with any of those. They have stated clearly that this is not a submission of no case. They have stated that clearly, and they have stated clearly that the only basis for their submissions is Order 36, Rule 4, 3, and CI 87, the rules that we have discussed. If their application does not fall squarely within those rules, my respectful submission is that it ought not to be countenanced. If they want to come back and say that they are not relying on the witness statement of the first respondent, for instance, if they want to come back and state that, that needs to be stated clearly, because then our options will also become clear. That is my submission.
Okay, let's hear you.
Yes. My lords, on point of law, lords, I wish to, with your kind permission, read the Rule 3C of CI 87. Lords, it says that a witness statement, yes, my lords, a witness statement shall be verified by a statement of truth. Nowhere does the rule say that the witness statement shall be sworn, as was submitted. Lords, secondly,
it was a question from the bench to counsel that a witness statement per se is not evidence, and it is not also an affidavit. And I think there was concession.
There is a statement of truth attached to it, and that's what this is saying.
My Lord, secondly, it is my submission that the petitioner, the counsel, cannot approbate and reprobate regarding Rule 3E. Lords, previously in the proceedings before the court, Lords, the proceedings of 29th of January at page 40. Yes, my lords, at page 40 and 41. This is what counsel said when counsel for the second respondent was trying to put issues from his witness statement to the witness. He says, that witness statement is not yet in evidence. It has not been adopted in evidence. My lords, with respect, the proceedings are being confused. And lords, at page 41, he says, my lords, with the greatest respect, what he is showing the witness was an attachment
to the witness statement that has not yet been adopted. Very different. So, my lords, my submission that...
My lords, respectfully, I cannot be misrepresented. I made it clear that I was talking about the election to adduce evidence. I think I made it very clear.
Lord, so it's my submission that Rule 3E, all the provisions are quite very clear, and my learned friends putting one interpretation on it on one day and another interpretation on it on another day is most unfortunate. Respectfully submitted.
My lords, may we repeat from the onset that this is not a submission of no case that we are seeking to address. Secondly, that there is nowhere in CI 47 or CI 74 87 where provision is made for submission of no case in a civil matter, and yet it is done. Now, my lords, the fundamental error with counsel's submission, in my view, is that the submission is secular, and I'll proceed. It's secular. The arguments are secular. Secular, not secuitous.
Secuitous. They want you to use secuitous.
No. My lord, I choose secular.
Is that CIRCULAR?
Yes. My lordship will see that Rule 3D says that where a witness statement for use at a trial is not served in respect of an intended witness within the time specified, the witness shall not be called to give oral evidence unless the court grants leave. Then 3E1 says, if a party has served a witness statement and that party wishes to rely at the trial on the evidence of the witness who made the statement, the party shall call, and I want to emphasize that word, shall call the witness to give oral evidence unless the court orders otherwise, or that party puts the statement in as hearsay evidence. My lords, one will see from a construction of this sub-rule that a party must first serve the witness statement. He must file and serve. And that statement, when he serves the witness statement, no, my lord. Yes. Yes, but it's a legal matter I'm advancing, and counsel for the petitioner has been. Yes. My lord, my point is that from the words of 3E, the party must have served the witness statement first before he relies on it subsequently. So the argument that counsel for petitioner seeks to make, that service of the witness statement means an election, is inconsistent with the provisions of 3E. Because 3E says that you will serve, and then you must state you rely on. So the two cannot be mixed together. Now, my lords, again, the court will notice that the words are, if the party wishes to rely at trial, then he shall call the witness. So, saying that I'm calling a witness is what indicates that you are relying on the witness statement. So when we say that we do not intend to adduce evidence, It means we are telling you that we do not intend to call any witness, which means that we do not intend to rely on our witness statement. So by law, that's the sense in which the argument is secular. He cannot say that the witness statement has been served, and therefore you have elected. It cannot be the case, reading from the text of the law. Then again, my lords, if your lordships are to look at the, then again, yes, it says, where a witness is called to give oral evidence, that is 3E sub 2. Where a witness is called to give oral evidence under sub rule 1, the witness statement of that witness shall, and he was emphasizing on the shall, that it is an obligatory thing. But that will only happen when he is called to give oral evidence. The shall will not apply when the witness is not called to give oral evidence. And then again, sub 5 states that if the party who has served a witness statement, again you see the decision between serving a witness statement and electing, does not call the witness, that means that the rules recognize a situation where you serve a witness statement that you will elect not to call a witness. Does not call the witness to give evidence at trial or put the witness statement in as hearsay evidence. Any other party may put the witness statement as hearsay evidence. My lords, therefore, we submit that a proper analysis of these provisions makes it very, very clear that the service of a witness statement is not an election to rely on it, or to give evidence. My lords, I will now look at the Smila Belbe case and say that in that case, yes. No, he cited it. Yes. 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 He responded to it, and I'm replying to his response. Legal, it's legal. Yes. My Lord, your Lordship will note that in that case, the Smala actually filed an affidavit in which he admitted to a fundamental matter in issue, namely that he had a British passport. That was the basis for the court saying that then you bear the burden of adducing evidence to explain how, if you had a British passport, you are still saying that you are entitled to be elected as a member of parliament. So it is a completely different situation from an affidavit which is saying that we do not agree with the interrogatories because in any event, when or if the occasion for cross-examination arises, you have the opportunity of cross-examining the witness. Yes, so my lords, that does not mean that the petitioner is committing herself to the first respondent is committing itself at all costs to leave evidence, such that he may have to come now to the court to seek leave, not to give evidence. My lords, now my lords will see that the issues set down for trial are five. And my lords, all of them deal with whether or not the second respondent cross the 50 plus threshold. That all the issues, even issue 5, which is whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the election. All the 5 issues deal with that matter, whether or not the second respondent crossed the constitutional threshold. Now, my lords, our point here is that counsel for petitioner cannot say that these issues require the first respondent to be heard, provided there's sufficient evidence.
You are being heard in reply. Yes. On points of law. Yes, on points of law. Confer yourself to your client's case. It's first respondent, your client.
Very well. My lords, finally, the English case law on this matter, that seems to be the hunting ground of counsel for the petitioner.
What is he hunting for?
He's hunting to shoot down the application or the position. My lords, I wish to refer your lordships to the English case of Society of Lloyds versus Sir William Otho spelled O-T-H-O, Jeffrey, J-A-F-F-R-A-Y, B-T, 2000, and EWHC Commercial 51. So let me go over it again. Society of Lloyds versus Sir William Otho, Jeffrey, B-T, 2000, EWHC Commercial 51, where the issue of a party failing or refusing to give evidence after a witness statement had been served on other parties in the suit arose, and a prayer was made for the witness to be compelled to enter the box. The court held as follows: where a party, after serving a statement of his witness on the opposing party in accordance with pre-trial directions, decided not to call that witness to give evidence, the court had no power to order that party to call its witness to give evidence in court. Unquote. I will do so, my lord. My lord, we therefore submit that counsel for petitioners' submissions in response are misconceived and do not address the thrust of our position. We pray accordingly.
My lords, an authority has just been cited, and I respectfully wish to be heard on that authority. The one that has just been cited. Very well, but my lord, I wish to make submissions in respect.
No, you can't. I'm sorry.
What?
You can't.
Why?
The rules do not permit you to.
No, I'm asking for, my lord, I'm asking for leave. In a reply, he cites an authority, and I'm not allowed to comment on that authority. Yes, but my lord, why can I not be heard as to why that authority is not applicable? No, but my lord, it would have been fair if he had cited that authority in his main submissions. Then I would have had a chance to respond. But if he cites it in his reply, yes, but my lords will not hear me on an authority that has been cited and on its relevance. Is that, my lords, I will abide by your ruling, but is that the ruling of the court, that you will not hear me on an authority that's been cited in reply. Your lordships gave leave for him to reply and to cite an authority, and you will not hear me on the authority. If that is your lordship's ruling, I will abide by it.
Can you give him the authority? Can you give him the case?
My lord, I had no hesitation in letting them out.
Yes, you saw it. You passed the report.
So that is the professional etiquette that we...
I know, that is why, Bishop, you do have it.
He has cited...
I even asked that if it is possible for him to make...
My lord, I'm not even seeking to have what they have read.
Yes.
I'm seeking to be heard in response to what they have heard. And without hearing me... So, my lords, my respectful submission is that the circumstances of this case are completely different from the circumstances of that English authority for two simple reasons. That authority is not about the holder of a constitutional office, of chairperson who determines the fate of an electoral process. That authority does not deal with such a situation, and the circumstances of this particular chairperson.
Have your lordship given him very well?
And the circumstances here, which I alluded to, should not be lost sight of. The second reason that that authority is irrelevant is because that authority deals with a practice in the English courts which are based on their civil procedure rules, which are enactments, which have particular provisions in regard to case management and so on. And the interpretation that the lordship the case was dealing with had to do with that. In this case, we are dealing with our statutory instruments, and I submitted earlier that none of those statutory instruments warrants what is being sought to be done.
Order in court, please.
By court, this petition is hereby adjourned to Thursday, the 11th of February 2021 at 9:30 a.m. for ruling.
Please be seated, please. With respect, be seated.
the only thing is the APM or
The victory of mo mama ya sisa wani ya mo alaba foto bani ya sankofa inchi John Mahama ni epe sankofa inchi John Mahama ni epe sankofa inchi John Mahama ni epe foto bani ya sankofa inchi John Mahama ni epe foto bani ya sankofa inchi John Mahama ni epe sankofa inchi John Mahama ni epe kwa ufuata bani ya sankofa inchi John Mahama ni epe galam se foto bani ya sankofa inchi John Mahama ni epe yenu yenwo sankofa inchi John Mahama ni epe Jafi Mahamo John Mahama ni epe Jafi Mahamo John Mahama ni epe yenu yenwo John Mahama ni epe yenu yenwo John Mahama ni epe na yepe sankofa inchi John Mahama ni epe sankofa inchi John Mahama ni epe yenu yenwo sankofa inchi John Mahama ni epe sankofa inchi John Mahama ni epe sankofa inchi John Mahama ni epe Omanu mo yedio Omanu mama Asisa wajini o Ema odinada o John Mahama ni epe Yenu yenu o John Mahama ni epe Ghana for ribe o John Mahama ni epe Sankofa inchi Ghana for John Mahama ni epe Sankofa inchi Ghana for John Mahama ni epe Omanu mo yedio Omanu mama Asisa wajini o Ema odinada o John Mahama ni epe Yenu yenu o John Mahama ni epe Ghana for ribe o Sankofa inchi Ghana for John Mahama ni epe Sankofa inchi Ghana for John Mahama ni epe Sankofa inchi 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 John Mahama ni epe Ghana for Mutina wabo Mahama Mutina wabo
to testify. You recall that when we applied for interrogatories, that is, we wanted to administer 12 questions to her that we thought were relevant and necessary in advancing the case before the court. She swore an affidavit in which she said the interrogatories should not be allowed, and that when it comes to cross-examination, those questions can be put to her. In other words, she at that point in time evinced an intention to be cross-examined on whatever evidence she was going to give before the court. Then also, when we wanted to inspect documents, you remember we served notice on her to inspect the original documents that served as the basis for her declaration on the 9th of December. Again, she swore to an affidavit in which she said the court should not grant us the leave to inspect the original documents on the basis that if it comes to cross-examination, we will take our turn in impeaching her credibility, in looking at those documents and their relevance to the case. And then also, during case management, orders were given for witnesses to file their witness statements. Again, Mrs. Jane Adukwe Mensah filed a witness statement in the matter, basically again saying that she was going to give evidence. So the point that our lead counsel was making today was a very simple one. There is evidence on record showing that she had elected to give evidence and to be cross-examined on the witness statement that she has filed. Now, we will not go into the merits or demerits of what she has filed because the court is yet to give its ruling on that on Thursday. But suffice it to say that the reason why we are insisting that she be allowed to testify is simply because, my brothers and sisters, this is not a debt collection case. We are not here dealing with a private matter, the private interests of private litigants. We are here dealing with the public interest. We are here dealing with the declaration of the results that reflected or is supposed to have reflected the sovereign will of the people of this country. We are here dealing with Article 1 of the Constitution that says that the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government must be exercised. And so, for her to have declared that the sovereign will of this country as expressed on December 7, 2020, elected Nana Addo Dankwa Akufo-Addo as President of the Republic, she has a constitutional duty to account to the people of this country for how she arrived at that conclusion. And that constitutional duty means that she cannot, under any circumstance, be allowed not to account to the people through cross-examination, because cross-examination is one of the mechanisms allowed by law for exacting accountability of litigants. And this is not an ordinary litigant, as I've said. This is a constitutional office holder. And so our case is very different from some of the, even the English cases that were being cited are of no moment when it comes to this peculiar matter that we are dealing with in court. So I'll stop here and take some questions.
So, Counsel, let me ask the first question. The impression that we get from the sitting of the court today is that there is somewhat a time-tested principle of where witnesses have the option of saying that they would not testify, but there seemed to be an attempt to say that that time-tested principle should be set aside and a new order should be introduced. Is that the impression we should get?
That is far from being the case of the petitioner. The case of the petitioner is that at the point where a decision had to be made by the Electoral Commission with respect to whether or not to testify, they made an election. They decided they were going to testify. And the rules are very clear that when you have elected to testify, you can't walk back from that election. And that is what we want. We want the court to hold her to that election that she made, both in terms of the affidavits that she swore before the court, basically pointing to our right to cross-examine her when it comes to her evidence in chief, and then also the filing of the witness statement. That is itself is concrete evidence of that intention to be cross-examined. And again, as a public officer, she has to account to the people of Ghana, and that is why we want her to take the stand.
Okay, sir, in most of the proceedings, the panel seems to rule that the legal counsel for the petitioner is not hitting the threshold to make this case relevant. Why then don't you rather...
I can barely hear what you are saying. Can you...
Okay, in most of the proceedings, the panel seems to rule that the legal counsel for the petitioner is not hitting the threshold to make this case relevant. Why then don't you rather, with the greatest of respect, channel your focus on the amendment of some of the constitutional laws and, as a matter of fact, CI 126?
I don't know what proceedings you've been watching, with all due respect, but the panel has not come to that conclusion. Not at all. Arguments have been made, and in fact, the respondents themselves have walked back from those arguments. You remember yesterday, they said something about a submission of no case. And I do remember that MPP communicators went, Bizek, they went to town saying that they were making a submission of no case, we had not crossed the threshold of the burden of proof and so on. Today, you saw that upon serious reflection, they walked back. They are not, because the consequences of a submission of no case are dire for them. They know that when they make a submission of no case, all right, then they will have to strike out their witness statement, their pleadings will have to go off, and the petitioner's case will stand uncontested, and all our release will be granted, which means that His Excellency JM will be sworn in as President of the Republic of Ghana.
I recognize the significance of the ruling that we are all anticipating. Are you able to share with us the effects on your side, whichever way this ruling goes?
No, we will not engage in hypotheticals as far as the ruling is concerned. And again, we don't want a situation where we are commenting on the outcome even before it has come. All right. The famous quotation from the court now is, when we get to that bridge, we will cross it. We hope that the bridge will be there when we are getting to it. All right. Thank you very much. See. Okay.
Abuzafo yabeda munyina masibiem na say board de ne akoso court tofa e wetwi kasemu a the medical can say de ne akoso court ene de nra yehun wo court no e yanwanwasem kese pa de ntia me kasa ne say Ewra John Dramani Mahama de asemi ebeto Supreme Court animi isi for de omanu ye aba de ne sa hye sakrata na se eye banodani ma isi chairperson Jim Mensa ono and sanso ye the returning officer for the 2020 presidential election. Ode ne sa hye sa anu ye na se wie ye no wa ye de lawyer for friend no affidavit of verification say adanse ana nanu disem wode ato court nanim ni nyina ye no kwasem ewi akira ye be case management a court ma order say isi for adanse for do say na mo be frɛ o mo se ba ko madanse ni hwan a o mo si Mensa the chairperson court ma order say by a certain date on fa na dance kratamra 22nd January 2021 Yama mi de nsa hye na dance krata ase a odi abre court. Nti odi ne answer aba with affidavit of verification or the witness statement aba na dance krata aba eno so statement of truth de akire nyina ne se adanse e was akrata no so bibia ye no kre. Ebiem yegusu aye case management mo be kaya lawyer Chachuchi Kata lawyer for the petitioner Esre court ne se Omomaye misa Mensa nsemfua be edu mienu na saa no yie ne beboa ama no kre wo saa asem we mu no ene atentre ne aye adwuma ye ma mi Mensa anu yie in opposing this request no the okan ne say emma court no oda ne say on answer saa questions no because John Mahama ne na lawyer fo benya kwanya during cross examination ebisa na sansem bisa ni nyina na kire say Mensa on different occasions not only in her answer and answer the witness statement mu but affidavit ye adanse a wasɔn ama court no anyanti ase say obeba adaka ni mu abedi adanse ne ye wasɛm bi a ye bisa no afɛ nra John Mahama awie the case na dance for miensa nyina di o madanse awie omunyina wura adaka ni mu with akukodro answer all questions are all sides the respondents had for them because omunim se no kretrodo no moka and omunim se omutim fita edu ye ma me so metena adaka mu a ye ma me se adaka ne pa de on tenamu ne entenamu kina wasesa na adwen on ma adaka ne mu na dance krata no ono an de ba yesese de akura se maka menwe yenti no yemfa na de ma no mfa nkofie oni adanse adan na won pese oba be di adanse na ya toto wano na ya bisa wonsem because in 2012 Owura Farijan eba court to defend the constitutional obligations and to show say abatwa sambre no ka say John Mahama we no na wa we ni ampa answered all questions it unya boni bia why wadwuma kama adenti ena akonta mredru udwane na eno ho asem ne yaba beka muhu say ye insist through our lawyer say court no enhye maame no na ometena daka no because ono ankasa obi amfa tu ansi ni tu so ono ankasa ene ka kire court ne say omommo saa ye interrogatories ne saa ye nsembisa no ntontwene because obetena daka ni mu a saa nsembisa ni nyire betimi abisa no. And so having intimated that to the court no on to me sanso nsesa na adwen ka say ene de memmabiem na de lawyer kra won say sebi onye dansi ni bia keke. Jim Mensah is not an ordinary witness in an ordinary case involving private interest. Or yet, the constitutionally mandated person, or not about why ye na ne sin in aso obobo resource na bibia woni team. Enti echinyagea aba figures wunyina no ono pe na obetumi eyi ano. Na busianfo ebia na munim de enti Jim Mensah on pese obewura daka nimu no. Na mo meyan kan kire mo. The entire Jim Mensah person be rather can even say onim say na kumam declaration na ya court ne say or hwehwema hwese per that declaration and the figures in the declaration you know o mampenya Kufuor nya more than 50% no Jim Mensah nim say won't mean justify Jim Mensah nim say na some wa kan radio so ni in the media say wa ye correction of the mistake you know enya no kure obetena daka nimu a ye be pa na wontoma she will be exposed. Because the ever-changing figures are hold on siano, a begun anymore. I'm a Ghana for you know who say Onyano Kwafo. A BMG Mensah himself from 13 now or the iron exhibit 4, which is the presidential declaration form one. The lawyer say of failing on 9 December at the Tare Dine who baby our year declaration. On his other canimua, a Hunsem Bisabeba, a Bema not dead, this says our form no. And your papa. She knows she'll be confronted with questions about the authenticity of that form and she cannot justify the authenticity of same. And until I will no. And until Mamuntie, dear Ebinumoka say, oh, NDC for an John Mahama and Timmy case, that is why Jim Mensah says, oh, ma. Your case I had about court only simple. Why a declaration? Per why declaration? Or Mampenya Kufuor do more than 50%. One kasa wa jia to musa wa yemfonso but ye kasa nei o declaration wa ye nyina ye ba ko pe nsachira ya wa ye no mu bia ni wa wo de wonsa sha ase amana be ye mra na wa gazette. There is only one declaration and it is that 40 declaration that has been enacted into CI 135 and has been gazetted and some fonso ni nyina no Jim Mensah na kasa jia tum omo corrections omo so ma ye ni nyina no e ya na dwoma na sem because figures ni nsisi so. And even if a correction papa mpoa ye declare ye enact ye gazette until we have presented a compelling and a solid case MPP for him said they have a case to answer crocodile the John near the drum and asemi omu ye nyina no omu suro. And you saw say the president of the bench at some point beside lawyer Kotampa say now kra when ya bra what asem we hu fifiri o ye Jim Mensah na easy for lawyer na. So we should let you know that because they were the beneficiaries of the unconstitutional conduct of Jim Mensah, any the easy for yen intino, or Musru Sema Meno, Ebeba Dakanim. I asked Seba ye Jayama court, na court de Atemuno, Abba. Aye, na Yadeno, Yanya decision on Yawadana, the general secretary, and they say, when I was here saying this for Yenia Sembia. We don't have any issue. Because the case is bogus. I don't know what's true. Let's not that anymore. Now, be exposed how hollow our cases. This is not the time for her to run. She must account for her constitutional duties.
Oh, you think for the
now does not meet the threshold of Article 64. Indeed, our position today has affirmed this assertion. It is a tried principle of law that there is the right to be heard, but inherent in this right is the right not to speak. The petitioner exercised their right to be heard, and they spoke. We have decided, as the second respondent, not to exercise this right. And in actual fact, a petitioner who has confidence, full confidence in his case, should be happy, probably popping some champagne or drinking some tea, because we have decided not to adduce any evidence. However, it is curious that the petitioner, on whom the burden of proof lies, wants the Electoral Commissioner to mount the witness box in order for him to use the Electoral Commissioner to prove its case. This is not heard of, and our application today was grounded, firmly grounded in law. Lawyers, when we go to court, decide the strategy we want to take. We, as counsel for the second respondent, decided to take this course of action. And we indeed feel that this is the master stroke and has, should I say, has disturbed the camp of the petitioner. And that is why they have made lengthy submissions as to why this should not hold. The court, we are in the bosom of the court, and we know that tomorrow the court will adjudge in our favor. We are hopeful that the court will rule in our favor. Let me land with a quote from Shakespeare in my favorite book, Hamlet, which says, "To thine own self be true, and it must follow as the night and the day. Thou canst not then be false to man. The truth is only one, and the truth is that His Excellency Nana Addo Dankwa Akufo-Addo was validly elected the President of the Republic of Ghana in the 2020 election." Thank you. We'll now take some questions.
Different number of occasions you have indicated to us that Chairman McMahon was always available with his pink sheets. Outside the law, I just want to find out, are you not worried about the optics, in the sense that you have insisted that your candidate won the election? The custodian of the documents, the court says, should not let the petitioner see the documents. They now say they want him to go into the box, and effectively your counsel agreed that she should not go into the box. The question is, if indeed your candidate won the election validly, what could be the damage of the EC chairperson confirming the obvious, which you insist you have the records to show?
As I have already said, as a lawyer, you have your strategy, and you decide which strategy to take at every point in time. We have always said that we are poised and we are at the mercy of the court. If the court decides that we should give evidence, our star witness is more than ready. But it is curious to note that the petitioner has all the documents that he is requesting for. The petitioner has not met the threshold that has brought us to court. Yes, there is a court of public opinion, but this is a court of law. And the reason why we are here is to challenge the validity of the election. It is to determine the 5 issues that have been set down for trial. And as long as these 5 issues have not been duly satisfied. We believe that the evidence that has been adduced does not in any way prejudice our case. So we have decided that as part of our strategy, and we bear the risk, we are ready not to call evidence. And I think that should be something that we should be allowed to do. In the court of public opinion, what it is that the petitioner himself did not testify. That is something we should all ask. Why is it that John Dramani Mahama did not testify in the matter? He is the one who has brought the matter to court. He is the one who, above all and beyond, is personally affected by the matter. So he should have brought the matter to court. When we speak about this court of public opinion, there are other avenues for redress. The Right to Information Act has been duly passed, and it was passed under the watch of His Excellency Nana Addo Dankwa Akufo-Addo. The rights under this act can be invoked. Parliament, the petitioner or any upstanding citizen who wants to ensure that the EC is held accountable, as has been bandied around in court when we are not here to challenge the validity of the election, can make formal applications in that regard. So we need to focus on the issues, the 5 issues that have been set down for trial by the court, and know that we are here because there has been a challenge to the validity of the election, and that is what is important. Per Article 63.3, the person who is elected as president, has to cross a 50%, more than 50% threshold. And that is why we are in court. It is not about laying to rest certain allegations that are unfounded. That is not why we are in court.
Just a minor follow-up. Will it hurt your case in any way should the EC chairperson come and speak and confirm what you believe is what actually happened, knowing very well that the people of Ghana have not heard from her, particularly related to how those mistakes which she has admitted to were occasioned?
As I've said already, it is not about whether it will hurt our case or not. We are poised. In any way, if the court decides that we should give evidence, we will give evidence. But as I said, 1, each lawyer has their strategy for their case. 2, and more importantly, we are here to challenge the validity of an election. You, the petitioner, cannot use the evidence of the Electoral Commission to prove your case. No, that is not how it works.
I admit that indeed the proof is on the petitioner in the ongoing matters. But watching from what happened in court today, that your side also opposed that the Electoral Commission, chairperson of the Electoral Commission, who was returning officer for the poll, should mount the witness box and testify. Are you not interested, like the rest of us Ghanaians who are, in knowing what really transpired on the 9th of December, the night of the declaration in question? And also, would it not be more of a validation through the court that indeed the president was validly elected and validly declared as such? On the matter of whether or not the petitioner has met the legal threshold in terms of proof, is that not left to the court to determine? I mean, in a number of press interactions for a number of days now, your side has always said that the petitioner has not delivered on that. Is it that determination reserved for the court, or it is reserved for your side to share?
The final determination is reserved for the court, but as a lawyer, you assess the case and you decide the strategy to take. In our estimation, the standard which we thought, we expected to be met has not been met. And as such, we think that the court, we pray the court to use the already existing evidence to ensure that it arrives at a final determination of the 5 issues that have been set down for trial. With your second question, I hope I remember. I think it's your first question. The Electoral Commissioner, I keep on saying, this Electoral Commissioner is very tech savvy. All all the results, all the documents have been uploaded onto its website. This is an electoral commission that even has social media handles. It is in line with the transparency and the need for Ghanaians to know that this information has been put on these websites. So anyone who wants to know what actually happened just needs to visit their website, visit their Facebook page or any other social media handle. The documents are there, and more importantly, the petitioner himself, through his witnesses, has admitted that he has all the documents. So there is no issue as to know what actually happened, because we all know what actually happened, and the documents to support same are available on the internet. And then when you come to the validation, as I said, the court is not here to validate who won the election. The petitioner has brought a petition challenging the validity. So if you are challenging the validity, then you need to show the court why this validity does not exist, or this validity is not what it is. So that is the burden of proof that is on the petitioner. And the court is not to validate what actually happened. So it's going into the actual issues, and that is what we are in court for. So let's always remember why we are in court. It's not about the public opinion, but for legal issues to be determined. Okay. So now I'll hand over to my sister party to give the tree translation.
Ghana Central for any addition or majibra or motion wofie. Mijidi say nyina eye ensama ewo election petition mu a eye former President John Dramani Mahama or the Abedan court no be ediso. Nanso so ansa na meko ne nesi wo court dem ho na me kan mo. Say eye petitioner no any Ghana for dodo na local and international observers ka ho. Mon Central for cry enam mofidi akese bebre so. Edi abofo mo mu call enkro bebre so ko hwe sa collation na ekoso at the constituency level, polling station, region, and national. Edi ho adanse epefe say ye de ye nim pefe say President Nana Danko Akufo-Addo eya ba ye koto on 7 December 2020 no odi nkunim prekope sabi eye former President John Dramani Mahama ena wanting ho asenti ne abepie mu court ha na sabi nsama e ka no court ha na aya yi no enyina so ne adanse enya abosremuka na sa obekan a ene da tosu dumiensa a court na sinkonwa wa ha na petitioner na nkasa o say ne bonyo election na ye koto on 7 December ne ekire enkenkan mu petitioner no out of 13 times a court na sinkonwa no we pie mu a ha say premier nu pe na nya no nko a o petitioner no kra na eye court hansama ekoso esunsunsanso onim se ebeka na se ne sebi NDC ni bi a wotu ne na abesi ha no ono ankasa kra wanyi ne ho danse ni amfa na danse ama medan court no samo bekan a eye nra petitioner na lawyer for se ensema omode bedan court enyina so enimu adanse enyina omode abegu ewo mu se ansa na court no be start esi nkonwa no no mo ankasa yi court na sutre se nyame adoma adanse fo num e na omo be frɛ omo form asemu megu nra na adanse fo miensa e na omo frɛ eye owura se edu nketia eye Dr. Michael Kwesa White ene owura Rojo Metal Nunu ene adanse fo pa omo frɛ say ye ka say yen sorry ntia mu say kian ne kin esese adanse fo mienu omu yi court sutre se omo be frɛ omo no omo nkofo omo mra atokos da bi yen ka sa efi se court ha say na ayaba no ye de emra ene ye adwuma enti sa mra na e ma petitioner no kwan se ma ne megina adaka mu medi adanse emfa moa ne case no sa mra na so na ma electoral commission chairperson so akwanya se won pese obegina adaka mu abedi adanse de abeboa ne case a ehu hia so obegina adaka mu enti na ye gina ha no na sa obekan so a eye petitioner no na dance for na lawyer for ensema na omo kan court dem ho no e kame aye say omo kira ade ba ko pe se eye adansefo miensa omudo mbegina adaka mu no ensama ombeto papa so ne omude beda court ni nyina kame aye say antimi ama enyina so nti a adesrede omude abeda court nanim sa court no enkase eye aba ma meji mensa o declare ye no eni emra no bo ebra anase eye aba ye koto ye no obi ani nkunim enti court no nhye na yensa anya nhyehyɛ foforo na eye former president John Dramani Mahama ene president Akufo-Addo omunsan kosi aka ni bio no oma dance for miensa na omu begina adaka mu ebe so aye se omu ka no kre no omu mu bia ni hono ma otimi ma adanse a etimi pagya omu koduru mpempen so a court no ebetu no ho asi o se saa de srede omu de abedan court omu de be mo omu enu nti omu se saa de a ene esese ekọ hayo esese ye hye EC chairperson ne keten se wo pe wo mpe o megina adaka mu ni antoto na no na ehe na wote esese wo sama obi a nipa na wasama no ono ne sai na so die se obeyi wadanse enya wo wadanse ni nyina so na esese o de bedan court no ebio ene ubetie lawyer penina no kasama petitioner na o se ai enam se ebra omude adesrede ebeto court batan yanim se nke yam o makwanya no mo ntoto electoral commission na no enyi nsemfo abi asa akwanya na ama no na ekye se ne ye nhye se EC ba panyi begina adakam na nya sa na court ne kan court no a ruling omude ba ye on that issue of interrogatories no almost say efri say eye ensema na petitioner na lawyer for atwere guru akrata so any set of questions omude be dan court no in interrogatories na ehu hia eye irrelevant enti na court no bogu ye court na antwere wo ruling no mu say enam se na ma me na twere e wa affidavit mu so onya akwanya say obegina adaka mu obeyi nsem na no nti ma na nya nti sa nsem na omo keka wa ha se ni nyina emfa kwan mu ebio mehu se petitioner no ne kasamafo ne lawyerfo ni bi begina adaka yanima omo ka kire mo se ai emese court dem ho de mrakwa mu de bia ne ani nkunim enti yamfa propaganda mbeda ga na adehye na omo nka ya semo maye na ada wunsura adenti na amegina adaka mu accountability nti adenti na amegina adaka mu ye nyina ye nim se ga na adehye ya na musifo wo mrahye bedwam asa eba no nkontabuo ne accountability a sabi omutimi frɛ isi no anase isi na adwumayefo ebre bia emo bebu nkonta ekire ga na adehye through parliament emo kasa adwuma amode maaye no mpempenso a ya akoduru ni na ha ne de yeko ena court na ya ba begina ha no eye petitioner no anchekire yensa begina court ha se oba for accountability also oba se declaration na isi ba panyi eye no ebu eye ga na mrapon no article 63 clause 3 enu nti ne egina ha o se declaration na ma me ne na ebu mra because obia anya 50% plus o se ebu mra because onu no ahuma bia eye nkontabuo num na ankoso ye ogidi se ebetima ye nsakiraye e wo results num enu nti ne egina ha enti se ne nipa ne begina ha na nsemfua na onu no de beda ga na adehye ama enu nyina so nti omutu emabunugu monten so ema ebihwere omunkwa ebinya ankwanhia ebinya abayamane no sa begina court one for nsemfua no mu bia medan court na ebewi ase no o se ye megina for accountability nti amesremo omuba omunkan omu se enye enu nti na omude ebegina court ha se ebio se petitioner no accountability de so omupa enya oba akofo ho ene eje accountability yenye bin free petitioner no ho sa ono ana Ghana fo akohoma a free aban no fotuom ene ye nyina ye kotokuom ye keka bo mu de ma isi ne so mo nko conduct election enu nti na candidates edumienu ana mo ye presidential candidate omu nyina na musifo ye mo carbon copies of a pink sheet any collation sheets from polling station constituency region and national na accountability nti na nka ehu behia se omampanyi dada se ode asem we bakot abetweman so a enko obeka se mene mama nyokuo enam accountability any dies no nko ne obu a ye wo maga na adehye nti enka nkonta ye bu ye no esunsunsu aso ni na nso so omo begina court ha omanfa accountability no ho nkonta ama amfa ho adanse ama na oma begina ya kase da bi ye de ye ni aso de bia maga na fo na oma hu so oma di nchonti eno omo de ya begina ha se adwane afiri nsam omo de beda court no ebe pre foforo se ne na mu nyina mu sete ye no ya judge eye ajudge for mutena adwam omuti obi anu asem second respondent a lawyer for me papa odi ani me yoru akoto ampaw ogina amra so isi lawyer penyin so just na menu no so gina amra so ese sa wo hwe high court civil procedure rules CI 47 no ma sa wo hwe order 36 rule 4 sub rule 3 any order 38 3e 1 any 5 as amended by CI 87 na yenshe obisa o megina adaka mu media dansie emra no enye sa na mra ne kire enti se wo beda court a oba fi se unim se wasema wo de ba no emu odu enya atentenhuo enya asawa unim asema wo de beda court enti na abaye ye medru court ha nwie emeka sama dansie no mu oha enti me baba beji adansie afri nipa amene no pre wo court ha no ho enti mesre mo se nsem na ya no mama na kofom na ga na fonzo so ate ase se sabi ne wa beda court e de akinye aba beto ha no ono ena se so ode ne nyina so ene na dansie ba enti nyame adom o china se court no sa sim eye nyame adom a ya wada anapa court no besim konwa na enne ensema epie mu application a eye first and second respondent a lawyer for the abedan court no wa bebu an eduru ho nso ye de no mu nso nkyeremu bebre mu medamu nyina amase. Thank you.
My ladies, my hey.